Welcome to Trinity University. I'm Danny Anderson, the president, and this is the 2018 Distinguished Lecture Series presentation. Just before I introduce our guest, I want to share a few things. Tonight's presentation will end with questions from the audience. We're going to take them in written form. So if you have not yet turned in a question, please use your card, write your question, and the Trinity ambassadors will make one last pass through the auditorium to collect your questions. So thank you so much for participating and helping us engage our guests tonight. Our distinguished lecture series is made possible by the Walter F. Brown family of San Antonio. And so I want to begin with a thank you for the incredible support they've given. So please join me in a round of applause for them. And tonight, it is a real pleasure to introduce our distinguished lecturer, Nina Totenberg. Ms. Totenberg is the award-winning legal affairs correspondent for National Public Radio, where she covers issues of the Supreme Court on shows such as Morning Edition and All Things Considered. Her coverage of several groundbreaking Supreme Court justice nominations has earned national recognition, including her coverage of the Clarence Thomas nomination, which earned the NPR the prestigious Peabody Award for its gavel-to-gavel coverage of events surrounding the nomination, and her coverage of Douglas Ginsburg's Supreme Court nomination, for which she was awarded the Alfred I. DuPont Columbia University Silver Baton Award. Ms. Totenberg has been honored 8 times by the American Bar Association. Esquire magazine has twice named her one of the women we love. She has published articles in the New York Times Magazine, the Harvard Law Review, and the Christian Science Monitor, just to name a few. Ms. Totenberg has won every major journalism award in broadcasting and is the only radio journalist to have won the National Press Foundation Award for Broadcaster of the Year. Please join me in giving Nina Totenberg a warm Trinity University welcome. So welcome to San Antonio on a very rainy day.
Yes, and thank you all, the brave souls, for coming out on a crappy evening.
Just to let everybody know a little bit about the roadmap for the evening, I have some questions here. We're going to begin with exploring with Nina some of her early experiences, and then talk some about the Supreme Court reporting that made her so famous. We'll broaden to some questions about the media today, and then end with some questions that come from all of you in the audience. And I want to thank one of our faculty members, Dr. John Herman. He has a political science class about the Supreme Court. And so we have some of the questions that were shaped by things that are being discussed with his students. So thank you, Dr. Herman. To begin, I want you to talk a little bit about your college experience at Boston University in the 60s, and then the decision not to graduate and to move straight into journalism. You know, talk about that transition, some of your early experiences, and maybe some of the barriers you had to overcome.
Well, I don't consider my lack of an earned college degree a badge of honor, but truth be told, my mother gets the credit because she saw that I was spending all my time working in campaigns and covering things for the school newspaper, and that I really wasn't very attentive to my studies. I didn't do horribly, but I didn't do brilliantly either. And she said to me one day, she said, you don't have to keep going to college if you don't want to. And I said, really? And she said, really? And I got a job working for the Record American in Boston, the Record, as it's called, or was called in Boston. And it was working on the women's page, which was, believe me, not journalism in those days that we would recognize as Journalism Day, but it was a journalism job, and there were almost no women in journalism in those days.
So talk a little bit more about being a woman in journalism in those days. What was it like? What did you do to prove yourself?
Well, even though the Civil Rights Act covered women, it was, at that point, in name only. Gender discrimination was as American as apple pie. And, when I would apply for jobs or call up about a job, it was not unusual to be told, well, we don't hire women, or we don't hire women for the night shift, because that was often a job that was open, or we already have our woman. That one, the last time I got that was in 1980. So it was a very challenging environment, to say the least, and one of the things that young women today find, I think, almost unimaginable is that my generation of women are perhaps, I wouldn't say tolerant of sexual harassment, but less militant about minor offenses, because we lived in an era when major offenses were tolerated, and there was just nothing you could do about it, number one, and number two, you were still so grateful to even have a job. So we really are a different generation. I am very glad that we live in an era when women don't have to tolerate abuse, but women of my advanced age perhaps have more tolerance for minor offenses than we should, because they appear to us relatively minor compared to a lot of the experiences that we had.
So you're talking about a lot of changes in terms of gender in the workplace. As you think broadly about our country, the 70s, the 80s, and the 90s, there have been incredible changes in our society. How do you think media's role has changed as our country has changed?
Well, and when I was a young reporter, there were 3 networks. That's all. There was something called the Fairness Doctrine, which said that in which if you had a complaint against a network's news coverage and you believed that they were not covering an issue or a candidate fairly, they, by and large, had to give you, if not equal time, at least fair time, and to make your point. If you could show that your candidate wasn't covered in a fair, roughly equal way in terms of time and allocation of resources, that kind of thing, or issues for that matter. The Fairness Doctrine doesn't exist anymore, and we live in the era of the Wild West of cable news and the internet, when people can say anything about anyone, just about, and facts often matter not one whit. You can make them up and it sounds plausible, so that Alex Jones can still maintain that that Hillary Clinton was housing pedophiles in the basement of a pizza place in Washington, D.C., and a guy comes with a gun and looks like he's going to shoot people there because he believed that. So this is an entirely different environment we live in, where people are free to make their own reality, and not necessarily people who are crazy. It used to be only crazy people made their own reality. Now, uncrazy people make their own reality. And I don't care if you're left or right. I'm sure you've had the experience of sitting somewhere listening to somebody you know to be an otherwise sane person say something that is completely crazy. And you don't know whether to have an argument or just bite your tongue. And if they're your really close friend, you usually bite your tongue, because it's not worth the friendship. You just move on.
So you're describing some of the differences in the media landscape between 70s, 80s, and today, and we've got this very hyper-politicized environment, very partisan. Can you think a little bit about moments where there was great division around Vietnam War, around Watergate, all kinds of things? How would you describe the quality of the polarization today compared to earlier periods, or have we been here before?
Well, we have in some ways. I suppose this is probably most similar to the Civil War period, or the period just leading up to the Civil War and just after the Civil War. But I think if you look back at the Vietnam era as an example, or Watergate as an example, in both cases, the so-called mainstream media was at various speeds covering both of these issues. And in the case of the Vietnam War and in the case of Watergate, as the mainstream TV and print press began to, I think the easier analogy in some ways is the Vietnam War, because certainly when Congress voted for the Gulf of Tonkin resolution, it didn't think it was voting for a lie. And it's very hard for a country to accept that it is losing tens of thousands of young lives for a cause that is futile. And it took a number of years to get from point A to point C. And it took, I think, the press just as long. But there were lots of people on the ground in Vietnam, reporters, who were going out in the field and covering what was going on in Vietnam. And over time, I think that most reporters came to view the fight as unwinnable and perhaps not even justified. So, as I said, there were 3 television networks. And they certainly weren't conspiring with one another, but as the body count was, after a while, you can conspire with each other to try to figure out whether you're being lied to about something as concrete as a body count. So if you has been out on this mission and somebody else has been out on that mission, and everybody gets together in Saigon at the bar with the number of people you know have been killed, and it doesn't equal what they're telling you at MACV, you know you're being lied to. And so I think that it took time, and ultimately, we had a draft then, we don't forget, we did not have a volunteer army. So people were going off to war and getting killed or getting injured or being traumatized, as people in wars have been forever, and coming back. And I think the country turned against the war. And I don't think you can credit the press particularly, nor can you credit protesters, because God knows they irritated people as much as they caused foment. But you had a much more, I don't know how to put it, a much more cohesive national sense. And it wasn't all at once. It took time. If you look back at, FDR in his, whatever it was, how many years was he president? It was 4 terms, but not 4 full terms. It was more than, 13 or 14 years. He only gave, I think, 18 or 20, something like that, fireside chats. We think of those as being like every week, but they were very extraordinary events, in fact. And when they took place, if you read history books, you see that the country was riveted. So you would be driving down a street in Chicago and you could hear the president's voice coming out of radios, in open windows, in cabs. Everybody was listening. And there was a sense of nationalness that I think we really don't have today because of our tribalism. If everybody watches what they only agree with, reads papers, editorial pages they only agree with, goes on websites they only agree with, defriends people they disagree with, and can't have a civil conversation, you have a very tribal country, and that's where we are. And I don't think the country has been like that. We've had lots of grief in this country from time to time, but I don't think we've been this tribal since the Civil War.
So you're making some very important points, and I want to come back to them a little bit later. But just thinking about your own career, and as you've moved through this and watched these changes, one of your real contributions has been to turn the Supreme Court into a topic of news. As I have looked at it and read and think about things, in 1975 is when you started working with NPR. And shortly after that, you had a story about the decision not to hear the appeal for the conviction of Hadelman, Mitchell, and Ehrlichman. Mm-hmm. And that story was very important in terms of creating the genre of being able to talk about Supreme Court decisions as an item of news. Talk a little bit about what you have wanted to explore as you've talked about Supreme Court decisions, and maybe how that has evolved as you've realized that people are interested in understanding more.
Well, that story was a scoop because it was not something that was announced by the court. And what it was you need 4 votes to agree to hear a case in front of the Supreme Court. And the story was that the then Chief Justice Warren Burger didn't have 4 votes and was holding up announcement of any decision in the case in hopes of getting 4 votes. I think he had maybe 3, but he didn't have 4. And he never did get 4. And I suspect I wouldn't have learned that this was going on if some members of the court hadn't been pretty ticked off that he was doing that, because that's not the way things are done. It's a fairly straightforward way of handling. There are rules for the way these cases are handled, and the Chief Justice doesn't just get to unilaterally hold them up. And so it was a scoop. It's probably, I believe it's the only time I've ever had a behind-the-scenes Supreme Court story that was a scoop. And they're extremely rare. They come, I'd say, once a generation. And the reason is that the only people who know what goes on in the conference are 9 people. And they don't really want to tell anybody outside that. They may talk to their law clerks. And I suppose the story may have filtered down to me because some of them were getting increasingly agitated as the Chief Justice was holding up this case over and over and over again. But I only know of one other real scoop like that, and it involved a reporter who was allowed into the conference room to do some video, and apparently went over and saw a paper in the fireplace, and so picked it up and saw what was on the paper and reported it, which was I never would have done, not out of great honor, although I have some of that. But because the votes change in these cases, they don't always stay the same, it would have been just suicidal, I think, to do that. So, and as I recall, I'm not quite sure it turned out quite the way it was originally reported. So it's the one place where they really can keep secrets, at least for a very long time.
So as you look at the variety of stories you've told about the Supreme Court, do you think there's been an evolution, or do you have a certain approach that you feel like you've used constantly?
No, I think in the beginning I was really fascinated by the process. What goes on? How do you make decisions? How are the votes taken? How is the conversation back and forth, which is basically all in writing, back and forth and back? How many times do you rewrite a decision in chambers before you circulate it? How do you handle it? And different justices handle it differently. Some never write the first draft. Some always write the first draft and then not much after that. I mean, it's really very different. And so I was very fascinated about that. The first probably 5 to 10 years even that I covered the court, but mainly the first 5. And I was able to write about that a lot. And justices were willing to talk to me about that because even though it's, because it's not top secret material, and they have different views of how, it's like having 9 law firms. They handle their work differently. And sometimes they really wanted to have more conversation in conference, but typically they don't have long conversations in conference. Almost all of their work is done by exchange of draft opinions. So I was sort of curious, how do you get from A to Z on an opinion? How do you get 5 people under 110? Which can be very difficult. So I wrote a lot about that in the beginning. And I still will very often give a speech about that, or people are curious about that. And does change a bit over time. But then I got just interested in the actual subject matter and what the different, you start to know more about the law and the evolution of the law and what's happening. And then, of course, there are always, nominations and confirmations, and those are very dramatic events sometimes. And in my lifetime, I have covered, I think it's something like, I covered every confirmation hearing for every one of the current sitting Supreme Court justices. And that was true even 8 years ago. So I've covered a lot of confirmations and failed confirmations. And I've seen how the nomination process and the confirmation process has changed over time. And it's very dramatic, the change. And that's worth, talking about, I think, some more. I'm going to write some pieces about that, I think, because I went back to, my agent asked me to prepare a speech about that. So I was up till 2 o'clock in the morning doing that for here and for a speech I gave last night. And I'm not quite sure how I can write about this journalistically, but I'll find a way. Because it's really actually pretty interesting.
So I'm going to follow up on the topic that you're on right now in terms of, we've just gone through a very contentious process for the appointment of Justice Brett Kavanaugh to the court. And talk a little bit about how you would frame why that was contentious and the kind of things going on, but then take a step back and just talk about the bigger picture that you're talking about in terms of the nomination and confirmation process and the ways that some people say, we ought to rethink it. It just isn't working.
Well, it isn't working because we are so polarized. And let me go back to 1968, which was the very first time I ever covered a confirmation, which was Abe Fortas's nomination to be Chief Justice from being Associate Justice. It was a Johnson appointment. And he was promoting him to Chief Justice, and he nominated a federal judge by the name of, wait for it, Homer Thornberry, to take Fortas's place as Associate Justice. And if I really want to count every nomination I've covered, I include Homer Thornberry because, of course, when Fortas didn't make it to Chief Justice, Thornberry went away. So Republicans and conservative Democrats filibustered the Fortas nomination because they thought he was too close to Lyndon Johnson and too liberal. And they succeeded because the filibuster which has been in place up until the Gorsuch nomination for 100 years, was a way, even though it wasn't used on Supreme Court nominees almost ever, it was a way of getting some sort of consensus because you needed 3/5 vote in order to cut off debate. So they filibustered the nomination to death. Then that fall, Richard Nixon was elected. He names a different Chief Justice, a far more conservative Chief Justice, Warren Burger, and then eventually some information comes to light about conflicts of interest that Fortas had, and he's forced to resign. And he resigns, leaving open a vacancy. And Nixon nominates Clement Haynsworth as part of his so-called Southern strategy to more closely align the Republican Party with the South. So he names Clement Haynsworth, who's a judge on the Fourth Circuit Court of Appeals, and civil rights groups and labor groups were very hostile to the nomination because they saw some of his decisions and they thought they were unfriendly to them. And then they found evidence that he had not recused himself in a couple of cases in which involving labor issues in particular, in which he held stock in the company that he voted on their side, or the subsidiary of the company. Now, understand that back then the rules were not quite as rigid as they are now, and so it was less clear-cut whether he absolutely had to recuse himself, but the case was made that he should have recused himself, and he was defeated 55-45. Now, Danny, I'm going to ask you this. How many Republican votes against him were there?
I do not know.
17. Wow. And there were an equal number or more Democrats, probably mainly Southern Democrats, but I think not exclusively, who voted for him. So he went down to defeat. He didn't quit. He went back to the Fourth Circuit. It turned out to be a quite good, and I would have to say moderate judge. And with the benefit of hindsight, I think he was screwed, to use a legal word. But Nixon was furious. He was absolutely furious, and he basically took an I'll teach him point of view tack, and he nominated G. Harold Carswell of Florida to be the next Southern nominee. Now, G. Harold Carswell had been a district court judge for I don't know how many years, a few years, and then he'd just been on the Fifth Circuit for 6 months, I think. And after he was nominated, he was a person of no distinction whatsoever. After he was nominated, it turned out that he'd given a speech 20 years earlier when he was running for a state legislature, pledging segregation now and segregation forever. Now, you can get over that 20 years later, and he renounced what he'd said, and that was okay. And then it turned out that then he was asked about what, if any, role he had in converting a segregated public golf course into a private course for $1 in order to avoid desegregating the public golf course. And he testified that he had no role that he could remember at all. Now, and then it turned out that the night before, he'd been visited by somebody from the American Bar Association Screening Committee who had gone over with him the incorporation papers that he, as U.S. attorney, had helped draft. So he lied is the answer. So he finally went down to defeat. It was closer. I think it was 51-45. I think some folks must not have been there or whatever, but it was very close. But still, there were, I believe, 13 Republicans who voted against him. Against Haynsworth, the Republican leader of the Senate voted against Haynsworth. And he did not vote against Carswell because he couldn't do that to Nixon a second time, but he told the opponents where they could find the votes. Now, this was in a time when the parties in the Senate and elsewhere were not all one way. So you had moderate and centrist Republicans and liberal Republicans and conservative Republicans, and you had conservative Democrats and moderate and liberal Democrats. And so we were not so tribal. Now the parties have realigned. They are being tugged in opposite directions by their extremes on the right and on the left, and I might as well confess here that I'm in the mushy middle. That leads to what we now see, I think, as a court that will be also pulled in opposite directions and will move probably more decidedly to the right, almost by the fluke of history of who gets to nominate, and the drive of Republican conservatives who have thought for 2 generations that the court is way too liberal and they were going to change that. And nothing makes Mitch McConnell more emotive, and he's not a guy known for being emotive, than what he's been able to do to make the Supreme Court have a 5-justice conservative majority that is probably more conservative than any court since the 1930s, and similarly that now 1/7 of the lower federal courts are Trump nominees. So he is thrilled about that, and he has been, I mean, I think conservatives have every right to crow over what they've done out in the open, and fairly to espouse their views as passionately as they can, and to win elections on that issue, while liberals really thought it was always going to be just fine for them, and it's not fine for them anymore. On the other hand, Republicans have been fairly ruthless about changing the rules. So Merrick Garland didn't even get a hearing for almost a year, President Obama's nominee. This week, for the first time ever, they've had confirmation hearings during a recess in the Senate Judiciary Committee. And the Democrats boycotted it. Now they're in the minority. That doesn't do them any good, but they don't really have much choice, I guess. Now, I've always thought that, when Republicans say, look, if the Democrats win the Senate, they won't confirm any Supreme Court nominee for 2 years. I've always thought that was crazy, but I'm not sure I think it's crazy anymore, because the Democrats feel so burned. It's tit-tat, and it gets worse and worse. And there's almost nobody to temper the brew, and the brew has gotten pretty ugly.
So are there procedural changes that anyone is talking about that you heard that seem reasonable, or people are just staying away from that completely?
I'm not sure that the procedure would change things. When Strom Thurmond was the ranking Republican on the Judiciary Committee, his chief of staff met with Steve Breyer, who was Kennedy's chief of staff, every week. And they would plan out what they would do, and each side knew what the other side had, and there were no secrets. Not even in the Clarence Thomas confirmation hearings when I broke the Anita Hill story. This was not news to Republicans. Biden had sent the FBI to interview Anita Hill, and he'd given the FBI reports and Hill's affidavit to the Republicans on the committee. They don't do that anymore. They don't talk to each other. The Democrats have not one iota of power, and you can be sure that when they win control, which they will inevitably at some point, they will not look kindly on their Republican colleagues. And each side, no senators generally don't even want to serve on the Judiciary Committee because it's so rancorous now.
So it is a hard topic. We're hitting all kinds of impasses there. I'm going to shift the conversation a little bit. And as you go back to thinking about your Supreme Court reporting, this is a much more personal question. I was listening to one of the NPR podcasts the other day, and one of the reporters said, Nina wasn't there, so I got to sit in her seat. Talk about the space as a reporter being in the Supreme Court. What is your seat like? And who is present? What do you see going on physically? Who else is there?
Well, the way the court is set up is there's the public seats. That's still I'd say most of the courtroom. And then there are a fairly large chunk of seats in front of the bar, which is the members of the Supreme Court bar, which basically means you've paid your $50 and you're not in bad odor in your local bar association, and now you're a member of the Supreme Court bar. And so there are members of the Supreme Court bar sitting there. Excuse me, I'm dropping my thing here. We don't want to do that. That'd be bad. And then there are seats. So we're the court. So it's sort of in a semicircle, not a full semicircle. It's a sort of an arc, so that one side of the bench can actually see the other side of the bench. That was a Warren Burger innovation, is that he had a new bench made so that they could see each other. And then, so if we're the arc, then there are press benches, seats along here, that actually have almost like kiddie desks for you to put your papers on, so you can take notes. And then in back of us, there are other press seats for people who are not regulars in little alcoves. And then behind them are people who really never show up for the court, except maybe once a year. And they're lucky if they can see, because they're in sort of the back corridor behind. So my seat is, so here are our seats. And the first seat is the AP, and the second seat is me, because I'm the senior member of the press corps. Now, it's not formal. It's only formal when we have assigned seats, and those are on very big argument days. Otherwise, we just all pretty much just sit in the same seats. I actually will take the third seat over because I can see better if I can. So, because I have a better view. And now that I really am very grateful that Justice Ginsburg is now on the other side of the Chief Justice, because I can see her again. Because as long as she was on the same side as me, it's a very high bench. And I could occasionally see the top of her head, that was all.
So what is it like? You said that the justices will talk with you. Is it difficult to get access to them, or in what context will they share information?
Well, you can, when a new person coming to the court frequently will ask to meet with some or all of the justices, and some will say yes, and some will say no. The chief doesn't usually do that. No chief justice usually does that. But members who are reasonably comfortable in their own skins will, if you're new on the beat, will meet with you. And when I was doing it, I was new on the beat. And I was young and cute also, and they were all men. But I think, occasionally I will go to see a member of the court just to chat, but that's extremely rare. Usually I see them socially at maybe the opera. Some of them all have been my friends since long before they were on the court. Justice Scalia was my friend long before he was on the court. Justice Ginsburg was my friend long before she was on the court. Justice Breyer was my friend long before he was on the court. So those people, I'm not about to stop knowing them, because they now actually have a job I cover. But the thing is, you can't talk about the court's business, because they would never want to talk to you again. So you just sort of get to know them, but that doesn't mean you find anything out about. You can sense something, you can tell when people are unhappy, but that's about the best you can get.
So what is just thinking about your career, decisions that you have watched evolve and come out, what are some of the most momentous decisions you feel like you have seen, and why?
Well, some I'm not sure we really knew were as important as they turned out to be. So Roe versus Wade, which was, I hesitate to remind people of this, it was 7-2. And one Democratic appointee and one Republican appointee were the two. And it really wasn't all that controversial then. It got more controversial over time because people cared about it. And sometimes they cared about it because they really thought it amounted to authorizing murder. Other times, I think there were political forces that generated more heat. But I don't have to tell anybody where we are on the subject of abortion now. The public opinion polls tell us one thing, but the politics of the court are something else. And so it's clearly abortion. I think that, oddly enough, because this is not as much of an issue today as it was then, but there was a time in the 1960s or early 70s when the court actually struck down the death penalty and eventually came to moderate that stance. And I never expected that at the time. It was a total surprise to me. Both ways, both when they did it and when they half took it back. And now there's a court that's I would say probably by a 5-4 vote, much more friendly to the death penalty. Justice Kennedy was really the genuinely swing justice. He was not opposed to the death penalty. He was opposed to it he was for limiting it to the, as best as he thought he could, to the most egregious circumstances. But I am under no illusions that Justice Kavanaugh has a similar view. I think he will think that it's completely up to the states and that there is no constitutional inhibition. I think certainly Citizens United, which overturned a precedent of just something like 7 years earlier, that had upheld McCain-Feingold and limits on campaign spending. And that and its subsequent decisions have really uncorked the most enormous river of cash that just as I was on my way to the airport, I heard just a little snippet on the local NPR station about what the money that had been spent by the Democratic candidate in suburban Virginia, which is something like $2.5 million. And maybe in Texas that doesn't sound like a lot of money for a congressional district, but I actually remember when that was a huge amount of money even for a Senate race. It's just, that doesn't count the money that's not raised for the candidate, him or herself. So I would say that I sort of understood that that was going to change our politics very significantly over time. And I don't know, those are the ones that come to mind quickly. I think that certainly the Obamacare decision was a big decision, but I think that it probably was, in hindsight, I don't think anybody will think it was a constitutionally important decision because it really basically deferred to what Congress had done. What I think is important is that it kept the court from being the central focus of the presidential election that year, which was 2012, I think.
So as you think about these decisions, and I think about some of the threads of things you've described, which president nominates a candidate, how moderate or extreme that person may be, I think we often think about the Supreme Court as being apolitical, and yet you are describing ways in which it is very political. And I'd say increasingly our country and everyone is looking at the Supreme Court as a political organization. What danger is there in that? Or what are some of the things that you have concerns about that we might think about discussing?
Well, I think it's very dangerous to have the court be viewed as a political institution. It's one thing to have people who feel strongly about their view of how to interpret the Constitution. And that often is in alignment with partisan views. But I actually don't think that Supreme Court justices, for the most part, I'm sure some of them feel in more partisan ways than we would like to think, but by and large, I think that their legal views are not partisan. They're ideological, but they're not partisan, and there is a difference. There's how you view the Constitution. Is it a document that was meant to evolve over time, or were you supposed to view it just as the Founding Fathers intended? And if so, how do you know what they intended, since they didn't agree like 6 months later on what they intended? But even so, I mean, these are genuine and difficult legal debates, but they're not partisan debates. They may, as I said, agree with partisanship. I mean, but for example, when the Supreme Court ruled in 1960, whatever it was, and laid down the rule of one person, one vote, that was an extremely partisan decision, because it meant that rural areas that were way overrepresented because they had relatively few voters, but were equal, but had whole districts that were, you might have had, I think in Tennessee, which was the critical case, that was like 15-1. So you would have 15 voters represented in an urban district versus one voter in a rural district. So it certainly was the political thicket, as Justice Frankfurter said. But the court had basically tried to figure out any other way to deal with it. They couldn't figure out any way to deal with it, and they thought it was unconstitutional. Now today, most people accept the notion of one person, one vote without even thinking. Nobody would want to go back to unequal districts, population-wise. So that is a completely accepted and nonpartisan decision in hindsight. But I do think it's dangerous when I understand the passions run very high in confirmation hearings and that a great deal is at stake. But when a nominee frames his defense in partisan terms, it's a dangerous thing, because courts don't have armies. We only follow what courts tell us to do because we have a certain element of trust in their fairness. And if we think they're completely partisan and not fair, if a substantial number of us think that, then the court loses its authority. And ultimately, that's how we settle disputes. If the political branches can't agree, that is ultimately how we settle disputes, whether they're commercial cases and civil cases or criminal cases, whether they involve allegations involving high officers or not. And if we don't trust the courts, we are getting very close to the kind of world we lived in the Civil War era, and that in the pre-Civil War era, and that's not good for any of us. I don't care what your political philosophy is, that is not good for any of us, because what this country is based on is the notion of ordered liberty, both order and liberty. And you can't have that without a court system that is generally trusted.
So I love hearing your talk. I want to open up and bring forward some of the questions from the audience. So if I could ask the Trinity Ambassador to bring forward the questions so that I could read them. Right here. Thank you. So I know we probably got many, and these have all been organized. So should the Supreme Court positions continue to be a lifetime appointment?
Well, now that conservatives have control of the court, and I think they probably do have control in most cases of the court, liberals are going completely crazy in a panic. And some of the, both in and out of academia, but in academia definitely. And some of the ideas I've seen proposed over the last month or so, or 2 months, are really pretty silly, including one that was written about quite seriously, that every president get 2 Supreme Court appointments. Shoot me in the head. I'd never get to go home at night. Increasingly, some people talk about term limits and the most plausible term limit is probably 18 or 20 years, because most Supreme Court justices join the court and it takes 4 or 5 years. They don't hit the ground running. It takes a while for them to really get used to doing the work at that level, so that they have a view of what they're doing. So 18 or 20 years doesn't sound crazy to me. However, that would take a constitutional amendment, and I don't see any way that would pass. At the moment, it wouldn't pass in conservative states. If liberals ever got control of the court, it wouldn't pass in liberal states. So, you know, go figure. I just don't see that passing. I don't see how that happens. So the next best thing is to pack the court. Now, packing the court is in terrible odor because of FDR's court packing plan, which he pushed even when it became unnecessary because one of the conservatives began voting to uphold New Deal legislation. But in fact, the size of the court is set by statute only. And it has changed at least 10 times in our history. And every single one of those times it has changed size for political reasons. In the Civil War, for example, the radical Republican Congress, after Lincoln was assassinated, well, first in the Civil War, the Congress changed the size of the court from 9 to 7 by attrition. That meant that that ensured that there were going to be, no, well, let's see, I've screwed this up. All right, so let's go back. So in the Civil War, they added 1 justice to 10 so that they could be sure of a pro-union majority on the court. And I suppose you could call it an anti-Tawney, anti-Dred Scott court. So then Lincoln was assassinated, and Andrew Johnson, a Democrat, becomes president, and the Republican Congress then puts the number of justices back to 7 by attrition so that Johnson will not have any nominees to the court. He can't have any nominees to the court. And then in 1866, when Grant is elected president, they put the number back from 7 to 9, giving him 2 more nominees to the court. So now they've got a court that is friendly to that Congress again. So, and this is repeated time after time over the course of history until about 1900. And between 1900 and 1955, in terms of confirmation battles, that's the most quiet time because only 1 nominee was defeated in that time. So there was a 92% confirmation rate. Before that, it was 69%. After that, it's 76%. So you can see that. Do I think we ought to pack the court? Really? Do we have to do that now? Is that a good idea? Do we want to start doing that? Is that one more bad idea we can have? I told you, I'm in the mushy middle. But that's the kind of thing that is being seriously talked about now.
So I have another question, thinking about the Supreme Court. Do you think that, which has a bigger impact on our daily lives, the Supreme Court appointments or circuit and district court appointments?
Well, in a more granular sense, certainly the circuit court appointments, because the Supreme Court only hears about 75 cases a year. But they are the cases in which the circuits disagree, typically. So they have to resolve those differences, and that's how it's done in the Supreme Court. But for most people, it's the state courts that have the most effect on their daily lives. And a lot of state judges are elected. Do I think that's a great idea? No, I don't think that's a great idea. Because they always have to worry about elections, so they're afraid of doing unpopular things.
So I'm going to keep going. I'm taking them in order here. Thank you for covering Justice Scalia's death while on vacation. What is your favorite NPR moment as their legal correspondent, and how many Nina Totenbergs do you have?
My husband has a couple. And there may be a couple sitting around the house somewhere, I don't know. I sign them like with a vengeance all the time for fundraisers. My favorite? Well, to be truthful, I did cover Scalias Death while on vacation. But I was in Tortola for a romantic Valentine's getaway with my husband, haha. And we had gone off snorkeling for the day with a friend who had a boat in Tortola, and got back, and I look at my phone, and it's been going bananas all day, or for hours. So I call in, and they say to me, Justice Scalia died. And I said, very funny. And they said, no, this isn't a joke. Now, truth be told, there is no justice over 70 for whom I do not have an obituary in the can right now. And news spots, written and recorded. So it wasn't as disastrous as you might have thought. So the first, they have the first, but I spent the rest of the vacation on the phone, and I tweeted our host took a picture of me in a rather décolletage sundress with a margarita in front of me on the phone, filing. And so I tweeted that, and my colleagues have never quite let me forget that I did it. I would much rather have been there, but that's why you do these things ahead of time. You can't put together a good obituary or a good retirement story in a few hours. It can't be done. You have to do lots of interviews. You have to think about it. You have to go look at all the things that they've written. What's most important? How can you get this into 8 minutes, 7 minutes, whatever the amount of time you're going to have? And you have to write a digital version of the story, et cetera, et cetera, et cetera.
So the next question, how is the Kavanaugh-Ford story different from the Clarence Thomas and Anita Hill story almost 30 years earlier?
Well, there are similarities and differences. I mean, the similarity is that in both cases, they listened to her, and everybody said, oh, this is over. And then they listened to him, and they said, no, it's not. Difference is that the Senate was controlled by Democrats in 1991, and is controlled by Republicans now. And there were, I think, 11 Democrats who actually voted for Clarence Thomas. A couple of them lost their jobs over it, but and another difference is, of course, that the Republican tack with Anita Hill was to destroy her if they possibly could. And I don't think anybody thought 27 years later that you could take a similar take no prisoners attitude towards Christine Blasi Ford, which is why they hired a woman to do the questioning, because all the Republicans on the committee are men. And they didn't want to look like they were bullying her or trying to beat her up. And they didn't. They just didn't. It didn't matter. They either chose not to believe her or chose to believe that she misremembered or thought that this was just a political game that the Democrats were playing, or that it didn't matter. And that's the way it shook out. And I have no doubt, by the way, that if, for example, Susan Collins had voted the other way, that Joe Manchin would have voted the other way too. So Susan Collins was the linchpin, and I thought she made a very good speech for her point of view. I think that it's not fair in some ways to think that she's never voted against I think she once voted against a district court nominee, but she's always voted for. In my 20s, I would have been completely dissolved by the kind of attack that I came under. And I wouldn't really have had any real idea how to handle myself in public, whether it was on TV or co-anchoring the hearings, how to proceed. It doesn't mean it was easy. It wasn't easy. It was extremely difficult. But I don't see how a 20-something-year-old person would have known how to do that. Certainly not, forgive me for the sexist remark, at that time anyway, a woman. Because I'm like most people, and I think perhaps more women than men, I like people to like me. I don't want to be hated. And being sort of heaped with pretty hateful abuse from time to time by both powerful and people who never met me, didn't know. I would come to work in the morning, and in those days we didn't have email after all, 1991. My phone mail held 36 calls, and there would be 36 calls. It would be filled, and most of it would be awful, just awful. And I would hit the delete button pretty quickly, but that didn't change how awful it was. And I was very glad I was not a kid when I broke a story that big. And so my advice to people is to just do the best you can and try to learn from your mistakes, because God knows we all make them, and you're going to make them. You're going to make them in your professional life and in your private life. And all I can say is try to do the right thing. You know, I was married for 20 years, and the last almost 5 years of my marriage to my first husband, he was very frail and from a head injury. And I've always been, it was very difficult, but in a lot of ways, in hindsight, those were very special years. And I never did anything that I was sorry for. I took very good care of him. And it is one of the best things I've ever done, was to be probably a better wife in those years than I had ever been before, because I thought it was really my duty to do that. And it's, you know, when you think about the things in life that you're proudest of, it may not be your professional accomplishment. It may be something that was really hard, but that you felt strongly about. And God has a way of rewarding us for those things, because I'm remarried and very happily remarried to a widower guy who I met, and we've been married for 18 years. And and we both did that. His wife was actually sick longer than Floyd was sick. So I think that those are the things you really have to think about in life. It may be a little more personal than the kind of answer you thought you would get, but I think when you look back on your life, you have professional accomplishments. I mean, who I am professionally is at least 50% of who I am. But the things that I've done in my life that I'm proudest of are not the professional things, because I know how to do those. Those aren't a matter of choice. You know how you're supposed to do your job. It's not difficult. You may have to work very hard, but that's not the same thing. It's the things that are really hard in your personal life where there are choices that you should make the right choice, the choice that you can live with for the rest of your life.
So thank you so much for a wonderful evening. We'll go back this way.